Mr. Chair, this is Andrew Ray for the record. It appears to be 4 o'clock and we appear to have a quorum.
Okay, so with that being said, we're going to call to order the February 5th meeting of the Mesilla Valley Metropolitan Planning Organization Technical Advisory Committee. I am your chair for the moment, Michael Garza from the Flood Commission. We'll continue with a roll call, starting on my far right. Going that way.
Loretta Gallegos in for David Armijo.
Daniel Sobrano, Doña County.
Did not pick up.
Yep, Kyle Lawrence, City of Las Cruces.
Richard Hanway, Road and Transit.
Ms. Dion, it did not appear to, was the red light on?
Tammy Dion, EBID.
Harold Love, New Mexico DOT.
Ben Serrano, Las Cruces Public Schools.
Mr. Chair, we have a quorum.
Okay, so we'll move on to item number 2, approval of the agenda. Does anybody have any comments or questions on it? If not, looking for a motion.
So move, Harold Love.
Ben Serrano seconds.
All in favor? Any opposed? Seeing none, agenda is approved. We will go to item number 3, election of officers. I assume that means we're going to take nominations for chair first?
Yes, Mr. Chair.
Okay, so we're going to open up the floor. Does anybody have any self-nominations or nominations of others for chair? Not all at once. No? Then I guess I will self-nominate myself. Just get this show on the road. Anybody have a second or opposition to that?
We do need a second, Mr. Chair.
Ben Serrano seconds.
Okay, can I call a roll
Yeah,
call for
yeah,
option?
Mr. Chair, yeah.
So, all in favor?
Aye.
Any opposed? Nope. Then I guess I'm going to continue being the chair, but I do need someone to volunteer to be vice chair. Anybody? Anybody at all? Kyle, Richard, Dan, anybody? Alrighty then. Harold. Trustee Harold.
I'll volunteer to be vice chair.
Attaboy. Appreciate that.
Mr. Chair, for the record, I'll say that you nominated.
Yes.
I'll say that you nominated.
Thank you, Harold. Anybody have a, well, I guess can I second, or I can't second because I nominated. Someone else have a second?
Second, Richard Hanway.
All in favor?
Aye.
Aye.
Any opposed? All right, we have new, not so new officers. So we will continue with the meeting. Item number 4, approval of the minutes from December 4th. Does anybody have any revisions noted or anything that we should be aware of? Seeing none, looking for a motion to approve.
Eddie Salazar, Town of Mesilla, motion to approve.
Second, Richard Hanway.
All in favor?
Aye.
Any opposed? Seeing none, minutes are approved. Item number 5, public comment. Seeing nobody from the public, we will move to actions items number 6, 6.1, amendments to the FFY 2024-2029 Transportation Improvement Program.
Thank you, Mr. Chair. I would at this time like to introduce Mr. Dominic Loya.
Good afternoon, Mr. Chair, members of the committee. So we are going to do the second quarter developments for federal fiscal year 2026. So we have a few of them. We have LC 00382 for federal fiscal year 2028. NMDOT is the lead agency. This is for the I-25 Engler Interchange ramp, which is for the addition of lighting and interchange and safety measures on the bridge that is currently there. This is moving the project to federal fiscal year 27, so it's moving it up 1 year. And this project will have an effect on Performance Measure 1, safety targets. We have LC 00330 for federal fiscal year 2027. This is, the lead agency is NMDOT. This is for the I-10 bridge replacements. So it is to replace a couple bridges over I-10. And this is just a change in one of the mile markers from 136.18 to 135.3. And this project will have an effect on Performance Measures 2, State of Good Repair. We have LC 00540 for federal fiscal year 2026. Lead agency is Doña County. This is local bridge replacement. This is bridge replacement of 721. And this is to increase funding for construction by $2,369,766 in federal fiscal year 26 for a new amount of $8,768,632. And this will also remove bridge number 7703. This project will have an effect on Performance Measures 2, State of Good Repair. We have a new project, LC 00541 for federal fiscal year 2028. This is also Doña County. This is local bridge replacement phase 2. So this will be bridge 7703. For the federal fiscal year, it will be $1,809,297, and this project will have an effect on Performance Measures 2, State of Good Repair. The BPAC did recommend approval at their last meeting. MPO staff requests that TAC to recommend approval to the MPO Governing Board for this series of TIP amendments. I will now stand for any comments or questions.
Thank you, sir. Does anybody have any questions or comments? Seeing none, we're looking for a motion with the action item requested.
So move, Harold Love.
Second? Anybody second?
Second, Richard Hanley.
All in favor? Aye. Any opposed? Motion carries. Action item is approved to the MPO Governing Board. We will move towards discussion items, number 7.1, Open Meetings Act presentation.
Thank you, Mr. Chair. This is Andrew Ray again for the record. I don't remember if I briefed the TAC on this, but you will recall that in previous years, the MPO had been represented by Mr. Sergio Estrada from Kemp Smith. Mr. Estrada left the firm in the middle of last year, and the governing board made the determination that they wanted to seek alternative counsel. So we did do so, and we brought on board the New Mexico Local Government Law Group, and Mr. Robert Kidd is the attorney that we have primarily been working with from NMLGL, and I'm very pleased to say that he is with us here today to give this presentation. So, Mr. Kidd.
Thank you, Mr. Ray and Mr. Chair, members of the committee. Thank you for having me today. I appreciate your time. And just by way of introduction, as Mr. Ray indicated, my name is Robert Kidd. We are currently the counsel for the MPO. And my background and experience is that I've been an attorney in New Mexico for 35 years. The vast majority of that time has been spent in-house representing local governments, both in Albuquerque and Santa Fe. And all of that is by way of saying I have staffed many boards, commissions, and committees. And so I've seen a lot of stuff. And so I want to do a presentation today to discuss the Open Meetings Act. And mostly as a refresher, some of this may be familiar to you, but I think it's always good to remind ourselves of some of the requirements that are contained within the Act. So I do have a slide deck, and hopefully I will be able to share that. So give me one moment. So are you able to see that?
Yes, Mr. Kidd.
Okay, thank you. So this first slide here is, again, just the contact information with regards to myself and our firm. The first thing that I want to mention is that the Open Meetings Act is a form or a part of a bundle of statutes that exist that are considered to be either transparency or sunshine laws, if you will. And the essential policy behind this act is that any sort of conducting of government business, formation of public policy should be conducted in open meetings, accessible to the public, so that everyone can hear and attend and listen to what is being said. Now, one note that I make here on this slide is that members of the public who may wish to record meetings and proceedings, whether by audio or video, are allowed to do so. Many times you may have members of the media attending a meeting and they want to make recordings, but if an individual wants to do so, they may, just so long as it does not disrupt the proceedings or the ability of the board or committee or commission to conduct its business. Some of the specifics with regards to the requirements under the Act are that any meeting of a quorum, and that term quorum of a member of a board, commission, or adjudicatory body, that's important, or any other policy-making body of the state agency or a political subdivision that's held for the purpose of either formulating public policy, discussing public business, or taking any action whatsoever within the authority or the delegated authority of that policy-making body should be held in an open meeting. And it has been declared vis-a-vis the Act that meetings be public at all times unless they are subject to certain exceptions that may be provided for either in the state constitution or in the Act itself. And we'll discuss a little bit about that in a moment. Now, one point I do want to make here is with regards to public comment. I noted on your agenda that you do have a place for public comment. Most boards and commissions do, but it is technically not a requirement under the Act, but it is a very common practice. And something I would just like to make a few comments about this. While it is allowed under the Act, there aren't any necessarily rules, but I would suggest a few best practices, if you will. One would be that public comments be limited to a certain amount of time, depending on the amount of people who want to speak. I've seen boards or committees limit time to, say, 3 minutes or 5 minutes, whatever's appropriate, just so that everyone knows how much time they're going to be allocated. Second, because public comment is basically an open time to speak, it does not necessarily have to be anything related to something that may be on the agenda or the mission of the particular board or committee that they're in front of. I have been present at meetings of different public bodies where people have gotten up and recited poetry or talked about something wholly unrelated to the body they were in front of. I've heard people give their picks for the next World Series, and there's nothing that says you can't do that. It's just that you may want to try to, again, limit the comments. And another point I would like to make is that this is not an opportunity to engage in extended dialogue or debate with a public speaker. It is merely their time to talk. If you find, though, that the speaker has a good point or something that you think is worthy of explanation, then my recommendation is that you ask that person to make an appointment either with staff or perhaps an individual committee or board member so that you can more thoroughly explore whatever points they may have to make. Recently, I was staffing a board, and the speaker got up and they had a really good point and something that was quite relevant to what this board was assigned to do. And the chair just respectfully said, that's a very interesting point. Why don't we make some time outside of this meeting where we can discuss more this issue more thoroughly. And again, that would just be with an individual member, not with a quorum. If it was with a quorum, it would be subject to the Open Meetings Act. Some requirements, again, that are contained under the Act is that public bodies have to give reasonable notice of their meetings. Now, the Act does not specify what constitutes reasonable notice, but the Attorney General has opined that somewhere in the neighborhood of 10 days should be sufficient. But again, it's not clearly defined in the Act. If a meeting is held with a quorum of the public body without notice, that's not considered an open meeting, and likely any actions taken during that meeting would be considered void or invalid. And this would apply to all meetings of a quorum of the public body. And bodies should determine what constitutes reasonable notice annually through an open meetings resolution. And in you all's case, I believe that is done vis-a-vis the resolution passed by the MPO, governing body. So the notice that is attached to a meeting must include an agenda, or where a copy of the agenda may be obtained. That agenda should contain the specific list of items of business that are going to be discussed during that meeting. And these agendas must be made available to the public 72 hours in advance of the meeting. Now, that is a specific requirement that is designated in the Act. And it is worthy of note that no action can be taken at a meeting unless an item appears on that agenda. And again, it's made available 72 hours in advance of the meeting. Now, there are certain exceptions that will allow for what they call emergency meetings. Usually, those are instances where there is not enough time to actually fulfill the notice and agenda requirements, but a failure to meet would cause some sort of harm to the public's health, safety, perhaps finances. These are limited exceptions, but it is acknowledged under the Act. Another requirement is that all public bodies subject to the Act are required to keep minutes. And at a minimum, those minutes should include the date, time, and place of the meeting, the names of the members in attendance, the substance of the proposals that were considered, and a record of any decisions made and the votes taken and how each member voted. Which leads me to the next slide, which is there should be no secret ballots. Because again, this is a part of the transparency laws that have been adopted in this state. The public has a right to know how each member on a board or commission has voted. These minutes are, in fact, a public record. The Act requires that draft minutes be prepared within 10 working days of the meeting, but those minutes do not become official until they are acted upon by a quorum of the public body, and that usually happens, as you've done today, at the next open meeting. So what about the circumstances where there may be a requirement that the public body has to recess the meeting and reconvene in a different location? It doesn't happen too often, but I have seen it happen occasionally. One time I remember specifically was when we had two different public bodies that had booked the same meeting room for the same time, and they had posted notice. Both had posted notice for their respective meetings. So in that instance, one body had to sort of concede and recess and move their meeting to another location. You can do this. How you do it, though, is that you have to specify where and when and at what time the continuation of the meeting is going to occur. You should post notice at the door of the original site and one other location with regards to where the meeting will be reconvening. And then again, once the meeting has been reconvened, it is limited to only those agenda topics that were originally appearing on the meeting agenda. Virtual or telephonic attendance. Now, it is allowed, but there are some restrictions here. And the first one is that the act itself does not specifically authorize telephonic or virtual appearance by a member to a meeting. It has to be authorized by some other rule or law. And in this case, I believe the authorization comes vis-a-vis the MPO's bylaws. The act does, however, say that if there is going to be telephonic or virtual participation, it must be difficult or impossible for the member to attend. And that is actual language out of the statute. The preference, obviously, is that members should attend in person. And if you are allowed to participate telephonically, it has to be in a way that everyone participating in the meeting can hear you and also can be heard. Now, obviously, during the pandemic and during lockdown, there were some loosening of these restrictions, mostly based out of the necessity of the times. But now that we're out of that situation, again, there is a very strong preference indicated under the law that attendance should be made in person unless virtually impossible to do so. So there are certain circumstances where an open meeting may be closed. And I'm not going to go too deeply into all of the exceptions because I don't think they necessarily apply or would apply too frequently for this particular committee. But I just wanted to make you aware there are 10 exceptions contained under the Open Meetings Act that allows a public body to go into what we would call executive or closed session. And the process for doing so, if it occurs within an open meeting, is that there has to be a vote of the public body to go into closed session. They have to cite what it is that allows them to go into closed session pursuant to those 10 exceptions that I mentioned. They need to state the topic, just a general topic to be discussed with some amount of specificity. And then the minutes must explain that only those specified matters were discussed. So some of the more common examples of times where a meeting may be closed would be with regards to discussion of pending or threatened litigation, certain purchases of real estate, certain personnel matters, and there are others. Again, I don't think we really need to do a deep dive into that because I don't think that it would apply very frequently to this particular committee. Rolling quorums. This is always a concern and something that people should be aware of. So the base principle here is that the Open Meeting Act requires that any time that there is a quorum of a public body and they are discussing public business, that should be in an open meeting. But there have been times and instances in the past in the state or in different local governments where there has occurred what they call a rolling quorum. And a rolling quorum does not necessarily even require that the members are physically present with one another at the same time and place. And the example that the Attorney General gives, if you have, say, 3 members of a 5-member board, so that would be a quorum, and they are discussing public business through, say, a series of phone calls or emails, then that is a discussion that is a meeting of a quorum of the public body and should be done in an open meeting. I had one situation where I was representing an agency several years ago, and they had a committee. I can't remember exactly the subject. I think it may have been a land use committee or something like that. And we discovered at some point that a quorum of this committee was routinely having lunches together and discussing public business. And when we found this out, we said, you need to put a stop to that. That would be a violation of the Open Meetings Act. And because you're doing this, you're discussing public business outside of an open meeting, and that would be a violation. Another note here that I want to mention is that the Act prohibits members of a public body from conferring privately during an open meeting by doing things like passing notes, sending emails or texts, or any other means of communication that, again, is outside of the public's hearing or awareness. And this is a problem not only for just Open Meetings Act purposes, but if you were to say be sending emails or texts during a public meeting, then those would be considered public records accessible to the public and would provide good evidence that a violation of the act has occurred. So what are the consequences when there is a violation of the act? Well, the biggest consequence is that any action that is taken in violation of the Open Meetings Act are deemed invalid or void. And so the remedy in most instances is that would require the committee or the board or the commission to have to reconvene and do it properly in order for whatever vote or action they were taking to be considered valid. The enforcement mechanisms that exist in the Act with regards to violations include the Attorney General's office, and they have statewide jurisdiction with regards to this. There's also mention of the district attorney in the counties of their jurisdiction. And then there is the ability of what we'll call, quote unquote, private attorney generals to also enforce the Act. As I indicated, the cure or the remedy for these violations includes a summary of the comments made at the meeting at which the claimed violation occurred, and then retaking a vote if a vote was taken. What I've seen most commonly is when there is a claim of a violation of the Act, is that someone will make a complaint to the AG's office. The AG will take that. They will then allow the public body or their counsel to respond to it. The AG will then make a determination of, yes, this is a violation, no, it's not. If they say it's a violation, then again, the public body has to go back and basically do it all over again. It is very rare, at least in my experience, that we see a standalone lawsuit based solely on a violation of the Open Meetings Act. Generally, where I've seen these in litigation or in lawsuits is it is one claim among many that are contained within the lawsuit. So very rare that we see a standalone complaint. And again, the usual course is that the AG gets a complaint, they make a determination, and then the public body acts accordingly. There are some penalties that are indicated in the Act. The base punishment would be $500 per offense. Again, rarely have I seen that enforced, but it does exist in the Act. And so that is it for my presentation. But I would certainly invite any questions that people may have with regards to any of the content or the materials that I just presented.
Thank you for your presentation. Does anybody have any comments or questions on it? Seeing none, we appreciate your time today. Thank you.
Right. Thank you all. Have a great rest of your meeting.
Thanks. Have a good day. We have one more discussion items. 7.2, call for projects, transportation project fund, presentation from MPO staff.
Yes, Mr. Chair, I would like to introduce Mr. Dominic Loya.
Good afternoon again, Mr. Chair, members of the committee. So the call for projects has gone out for the Transportation Project Fund. These were emailed to everybody probably about 2 weeks ago. So we're just going to go briefly over what's required for them and what is allowed. So starting out, their eligible projects are environmental and other studies, planning, design, construction, and then acquisition of rights-of-way for transportation infrastructure. And I should stress this is all state-funded. So therefore, that's why rights-of-way acquisition can be done. So we're going to get into the application now. What's going to be required is a cover letter, an overview of the project. If you intend to apply for a hardship waiver, the timeframe of the project, verification of funding to complete work, what the project category is it locally owned, rights of way, and does not include any federal funds? Is it an MDOT or a national highway route? Then you'll need the category of the project feasibility form, which we will get into here in a minute, because that is one of the requirements that will have to be done ahead of time. Resolution of sponsorship from the governing body with a 5% match. A map of the location, and then letters of support from owners of the project of the rights of way if local entities do not own the rights of way. So the project feasibility form will be due on March 20th. Basically, we'd like as much of the application as possible by March 20th. There will be a project feasibility meeting on March 31st with District 1 of NMDOT, which they will give feedback on the feasibility form and as much of the application that is put together by that time. And ways to improve it. The full application will be due April 10th. This year we are allowing more time for things to get done. So there will only be 3 presentations. The first one will be to BPAC on April 21st. The second one will be to TAC here on May 7th. And then Policy Board will rank them. And there will be a resolution and action item on May 13th. And then MPO staff will upload to the NMDOT FTP site by May 31st. May 31st is the last day that we can upload it. So that way we also build in some time so that if after Policy Board, they have recommendations for some changes to the applications, you can get those done and then get them back to us. Generally, it's usually minor things from the Policy Board. I'm sorry, the Governing Board. So this pretty much will be the timeline for the TPF project this year. And I will now stand for any comments or questions.
Quick question. The TPF funds aren't for federally funded projects. If it's phased and one phase is federally funded, could a subsequent phase be out of TPF funds?
I would defer to Mr. Love on that one. I am not exactly sure how they would handle that.
I think the only way that can work is if the one phase is completely completed and completely closed out before the other phase begins.
Okay, thank you. Anybody else have any questions, comments, concerns? Nothing? Thank you. We will move to item number 8, committee and staff comments. We'll start with City of Las Cruces.
Yes, Kyle Lawrence, City of Las Cruces. We only have one update. That is that I believe in 2 weeks, we will start construction on the intersection improvements at Walnut and Loman. So we can all look forward to delays getting to Sprouts and McDonald's.
What's the timeline on that project?
I believe that was 4 months. I think they're planning to wrap up around the middle of May.
Doña County?
Right now, we have nothing new to add from last meeting.
Town of Mesilla?
Eddie Salazar, Town of Mesilla Community Development. The only thing I got to comment on is on February 17th. We'll be having a hearing in Mesilla regarding New Mexico DOT project there on University. There are some concerns from some of the citizens along that pathway that the grade of the exterior land is much higher now than the properties that it's adjacent to that highway, and I'm talking 3-4 feet. So as they're using that trail, proposing to use that walking trail, it's very visible to go into their properties and such. So there's a lot of comments and concerns about that. So Town of Mesilla, what we've put together is a packet to a proposal to amend some of our codes to allow those residents to build their fence line much higher than 6 feet. That's the maximum that's allowed. So it will help protect and secure some of those properties.
So you're referring to the drainage that's coming off of the path that they're concerned about?
No, what it is when they install that, when they widen it, there used to be a mount there where the ditch was. And for one, that would protect or keep people away from the property line. And two, is the grade now is much higher on the walking trail than the actual properties itself, about 3-4 feet. So as they will walk, thinking as pedestrians and such will use that trail, their properties are exposed to privacy and safety, obviously.
Okay. Las Cruces Public Schools?
Nothing at this time, thank you.
Roadrunner Transit?
No updates.
South Central?
Nothing at this time, thank you.
DOT?
Harold Love, New Mexico DOT got one active project to report on. New Mexico 101 University Avenue. The following traffic impacts are in place. Only one lane of eastbound traffic will be open on New Mexico 101 between the Avenida de Mesilla and Main Street. And traffic heading westbound is detoured to West Union Avenue. Access will be maintained to all residences and Zia Middle School. And the project is scheduled to be completed by the fall of 2026. That's all I have.
MPO staff?
Thank you, Mr. Chair. We do have one thing that I want to update the committee on. We are still working on the MPO bylaws to get those revisions to reflect the transition that we just recently underwent. We had a bit of a delay. Some other things took priority, so we had to set the bylaws work aside. I anticipate, though, that we will be able to get started on the bylaws work again after the governing board meets next week and elects the new executive committee. So I am hoping, I'm not promising, but I'm hoping that I will be able to give a presentation to the TAC on the revisions to the bylaws, hopefully next month, although should definitely be by April. So we can all, it's not going to be terribly exciting, but we can all look forward to that. And that's the only thing that MPO staff has for today.
Sounds good. Item number 9, public comment. Not seeing anyone else showing up. So item number 10, looking for a motion to adjourn.
Kyle Lawrence, City of Las Cruces, making a motion to adjourn.
Richard Hanley, second.
All in favor? Aye. We are adjourned. Have a good day, everyone.